Hello there. Welcome to our lessons on international business communication skills. As part of that program, we are going to take a look at global contracts. And as an international executive, you are going to be involved certainly in global contracts as you do business with your international partners. So in order to give you more information on how contracts are viewed by your international partners and just what the basics are in terms of those contracts, we're going to start our lesson today looking at the basics of global commercial contracts. Of course, contracts are contracts, but we're going to start going through the basics of what is a business contract so that everything is absolutely clear. The way that you see a contract and the way that your international partners see a contract has to be shared views, and therefore we'll go through this step by step so that there is no misunderstanding. A business contract is actually, as you well know, a legally binding agreement, and it is something that is exchanged between two partners. It helps an agreement be enacted. And if a broken agreement happens, it possibly could result in legal action. Sometimes this may mean that you go to court, or it could mean that there is an out-of-court settlement with payment of damages by the concerned party. However, in order to avoid that kind of action, the idea is to draft a very solid agreement. And to have a very solid agreement will mean that you are very confident that you've negotiated the best terms for your business. So first up, try to draft a very solid contract, a solid agreement to avoid any possible litigation or any possible legal action. This is the aim of having an agreement, so both sides can work together. Now, a business contract, from many points of view, is used for various businesses. Depending on what your business is, you will find that there will usually be a business contract. Even if you're going to hire an independent contractor to do work for your organization, even if you are just going to provide goods and services, or whether you're dealing with real estate or partnerships and joint ventures, franchising, all of these kinds of businesses require contracts. All of these kinds of activities require a contract. And a contract will state out very clearly what is necessary for the agreement to be enacted. Perhaps in your line of work, you are selling services, IT services perhaps, to an overseas provider, or you are buying the services of a provider. In either case, you will need to have a contract that draws out very, very clearly what each party is involved in and what the arrangement is to be. Some people say that an oral business contract, just word of mouth or a handshake, is something that they would be happy with. They say that, yes, we trust our partner and this is all we need. We will do a handshake and that is it. It is actually a spoken agreement, and it can be as valid as an actual written contract. For example, if you have been promised that a job will be complete for a monetary or perhaps other kind of compensation, you have created an oral contract. An actual verbal promise is a kind of oral contract. And in many countries, they can be legally enforceable because you have promised to do so. But sometimes the oral contract, as you may well understand, is frequently misinterpreted. And because it's only words between two people, this is the reason for that. In a court of law, it may be difficult to prove what one party said to the other because it's actually your word against the other party's word, even though you are quite clear in what you said. An oral contract may not stand up in a court of law, basically because there's no proof of what was said. So bear in mind that even though you may feel good about your partner, or even though you may feel that a promise is someone's word, at the end of the day, if you are representing your company or your organization in business, an oral contract will not stand up in a court of law if things do go wrong. Actually, we enter into minor oral contracts almost every day. But if we really do sit and think very carefully of the consequences of something going wrong with that contract, that promise between two parties, then we really do need to look more closely at how you can protect yourself and your company in the case of something going wrong there. A written business contract, of course, is much easier to uphold than an oral one. Reason being, it's quite simple. There is reference to what has been said, and it has been written. It has been written on paper, and it also maybe has been sent electronically. A written contract is easier to prove when terms between two parties are discussed and argued over. Who said what is not just a matter of what was heard. It can be documented by what has actually been written and what has been signed off on. The language is very, very clear because it is in writing. It's on paper and it can be seen. It is recorded. Whether you're a small kind of operation or whether you are dealing with major business enterprises, a written business contract, including specific details about the agreement, is the way that you should be looking. It will protect you in the long term. It will give you that safety factor, regardless of whether you really do believe that your partner or your customer will honour their end of the agreement. So to be safe, written business contracts are the way that you should proceed in international business. Normally, a contract will hold certain details. It should actually be labelled contract or agreement. In international terms, this is the norm. This is the standard. So there's no misunderstanding as to what it is. So quite clearly, it is a contract or an agreement, and this should be very clearly labelled at the top. Items that should be entered in the contract, of course, follow a pattern. The date of the contract, very clear, and the names of all the parties involved. The names should be written in absolute clarity with no misunderstanding, whether it's a company limited or a joint venture party or whatever it is. There should be no misunderstanding as to the actual full name of each party. Of course, the details of the service that you will provide or receive need to be outlined in absolute detail, step by step, point by point, without anything missed out. And in terms of payment amounts, that is a very high priority as well. All payments must be defined very well, and payment due dates. You can actually make a contract out where payment is perhaps not received in one lump sum at one time. Depending on the kind of service that is provided, you can make or receive incremental payments once a service is complete. So a contract can lay this out very, very clearly in a step-by-step approach with regard to the way payment will be made. And of course, there should be an area which covers interest on late payments. These entries are the norm in terms of writing a business contract. And they are fairly well accepted in the international arena. Also, in that contract or agreement, you would detail the deadlines for services due. And sometimes the wording you might see is time is of the essence. This is a clause that is commonly used, and this implies that you have a timeline on the project. Time is of the essence is frequently used, as I said, in international business contracts. So try to become familiar with that terminology. Of course, expiration dates of the contract are important. Contracts do not last forever. The terms and conditions also are not available at the levels that you have implied or detailed in the contract forever. And therefore, you do need to think through what the expiry dates are of the contract. If you're wishing to renew the terms, then put that in as well. Or perhaps this is just a contract written for a certain period of time and it is not renewable. Then those entries do also have to be made. If, unfortunately, there may be a breach of the contract, and this may happen depending on the nature of your business and the other party. If there are damages caused from the contract being broken, then this also has to be put in. A court must award certain costs if a contract is breached, and certain amounts that you deem or that you consider are applicable need to be entered in here. You need to enter what compensation is actually going to be required if the project or if the contract is breached. And these are things that you have to really think through very carefully with your legal departments or with your senior executives when they're drawing up the contract. Also needed in a business contract, which is normal, is the termination conditions. What will cause this contract or this agreement to be terminated? It could be that both parties decide not to continue their relationship. That is an example of a termination that you might need to enforce. So termination conditions need to be thought through again in full and then need to be highlighted in the body of the contract or agreement. And then we find signatures. Signatures of all those parties concerned and, of course, witnesses involved. So we find that there are the usual practices, the normal entries that go into a business contract. And in international business, it's fairly clear that all of these entries must be completed and must be in your contract. We are now in an age of e-commerce, and a lot of documentation is passed through email. And to actually understand whether email or documents passed via email will stand up is very interesting. Some organizations in some countries prefer to have hard copies of everything. They consider that the hard copy and the actual physical signature is the only way that they will conduct any contractual business. Some organizations, however, are moving forward, are a little bit more progressive, but generally to follow the rule of law is the most important way to protect yourself when you're doing contract work via email. And electronic contracts and signatures are valid under what we call the Electronic Signatures in Global and International Commerce Act. And that was signed into law in the year 2000. There is e-contract software that can provide an I agree checkbox. So when you receive a contract or a legal document via email, you can click that box which says that I agree. So that means you can send and receive written contracts online and have the parties sign electronically. If you just reply to a contract that's been sent to you via email by simply writing sounds good or sounds good to me, then there could be a question as to whether that is actually legally binding. So to be safe and to be clear on it, try to set up your software so that there is the I agree click box so that you can formally reply and let your international partners know that you are formally replying by using this I agree click box. Even though it's easy and quick and you don't have to be in the same country, even though doing e-contracts and e-signatures via email, and even though they may be valid, as I said, many businesses do prefer to have written signatures on contracts because sometimes e-signatures can be subject to legal challenge. There are a lot of concerns with using the internet to do such contractual work. So if your preference is to try to sign things face-to-face on hard copy with actual written signatures that have been done in front of you, if your preference is this, it could be said that if anything does go wrong in your agreement with the other party, then it will have more chance to stand up in a court of law. It's up to you how you view this and how your company or organization is going to pursue this particular aspect of contractual work. It could be that you have a legal company representing you, and of course they will take care of all these matters. But if you are interested in the way that things should run, and if you would like to have input into how contracts are signed, it's well worth knowing these points. And that, as I said, e-contracts can stand up. There is an act to support them. However, the norm, the usual way of doing business is through handwritten signatures and hard copies. Sometimes, though, invoices can be prepared electronically and signatures are accepted. That is quite the norm now with invoicing. Sometimes an agreement can, depending on the scale of the agreement, sometimes that agreement can be accepted over the internet and later the actual written documents and signed documents are put in place when both parties can meet face to face. So, in order to pursue internationally with business and to look at the way contracts are viewed, there are some tips here to help to make your contract as clear and concise and as thorough as possible. One of the most important things you can do is to be specific. And to be specific means that you don't have to actually use legal terms to the extreme. We call legal terms the jargon. This is the language of legal contracts. And I'm sure that you have had the experience where you have read a contract and you have come away feeling absolutely bamboozled or confused by all the flowery words or all the legal terms that are used. And sometimes that kind of English is difficult to understand. It seems to ramble on and on when, quite simply, a few points could be said instead of all the flowery language that goes along with that contract. So, to my mind, and I do believe to your mind as well, the best contracts are those that are clear, specific and focused, with wording that is quite simple and concise, not too lengthy, so as there is no confusion. You don't want to be reading 20 sheets of paper when you could actually read about 8 for the same information. For example, if you are planning an event and you need 150 tables delivered by a certain date, you may not want to specify, or you may want to specify not only the date but the time of delivery. So this is what I'm saying. Just even for something simple, you need to specify all the things that are involved. So everything is very, very clear. When we say dates, say also the time. A day can be from 7 a.m. in the morning to midnight for delivery in some circles. So to be clear and to avoid any misunderstanding and anything going wrong, for delivery of those 150 tables, you would say the 25th of October 2009 at 10 a.m. precisely. So that sets out the specifics. That's just a very, very minor example, but it shows you how the specifics make things clear. And when things are clear, things may not go wrong. People will understand, and it is written down. In the morning is very, very general. 10 o'clock, 10 a.m. or 10 to 10:15 is very specific. If you do this at the beginning of a relationship and you try to get both sides into the habit of being specific, particularly about dates and times, then it helps to avoid arguments that might come along later on. Clarify things. Always ask questions. One of the greatest mistakes that we make is that we assume somebody understood what we said. We assume that the other party knows exactly what we meant. So whatever you require to be done, not only the specifics of dates of delivery, but also all the other things that you require to be done, make sure that they are clear and ask questions. If you find that you are not sure about what should be done or what the terms are, ask questions. And make sure that your other party in your association together, make sure they get into the habit of asking questions as well. Try to get these details sorted out actually when you're at the negotiation process. These sorts of things can be worked out through problem solving together when you're sitting down and discussing across the table face to face. And when they are clearly defined then, it makes it much easier later on when you're putting them into the actual contract or agreement to have things very, very clear. So you're at the contract stage, everything is clear, you don't have to go back and work out what the conditions are. Always clarify. Don't be afraid to ask, and do it preferably back when you begin negotiating. I know that perhaps in your line of work, you may be involved in more technical aspects. You may be involved in an industry where you are dealing with telecommunications, for example. And perhaps knowing the law is not part of your job role. But what I would say to you is that if you are an executive or a senior manager who is involved in doing business with international partners, then it is preferable that you try to study up and get a knowledge of the laws that pertain to your local conditions, as well as regulations that involve international business. It doesn't mean that you have to study and become a lawyer, But what it does mean, and what I am saying to you, is try to improve your knowledge in this regard. Having a very good, sound, general knowledge of the laws will really help you when you are doing international business. You may not become the expert, and indeed that is not what is necessary for you, but you do need to have a sound knowledge, and showing that you do have a sound knowledge will certainly help at the negotiation stage of your business. Try to check the relevant codes that pertain to the subject matter of your contract. For example, if you are in the property business, try to ensure that you have guidelines at hand so you can quickly check what codes you might have to follow. Research a little bit online. Go to your local Chamber of Commerce or consult with your legal department, just so as you have a basic knowledge of what you're up against or what you need to know in order to get this process moving. In telecommunications, I think there is a lot online that you can check, which is basic knowledge. And once you have that basic knowledge, you perhaps will gain a little bit more confidence and know what to look for when you're at the negotiation process. In my previous discussions with you on negotiation, having all the knowledge in the beginning and preparing in the beginning before you go through that process will help you immensely. So this is part of that preparation. Have a sound backup, have a sound background on the laws of the country, perhaps, that you are dealing with. Go through and search online. There is information available that you can read up on, or you can go to your legal consultant or your legal advisor here in your home country to get that basic information. In any contract that has been drawn up between the other party and yourself, sometimes we may not have the time to read it carefully and thoroughly, and we put a certain level of trust, of course, in those who have formulated that contract. However, a general rule that should be followed is take that time to read the fine print. Sit back, have that coffee or 2 or 3 cups of coffee. Don't rush, and read that fine print very, very thoroughly. You have to understand that agreement and all those terms, and your signature is going to be on that contract. So, to say that I assumed something or I didn't know, those statements do not, I repeat, do not hold up in a court. If you have signed that agreement, it is your responsibility to read everything thoroughly, even if the fine print is very, very small and you have trouble reading it. Make ways that you can enlarge it or zoom in and read that contract. Have it enlarged, photocopy it so the fine print is enlarged, that it makes it easier to read. Sometimes you have to be careful with the fine print, with all those details that are in there. Maybe something has been left out, so it is your responsibility. In no uncertain terms, it is your responsibility to read every single word. If the details are there, it is your role to read them. Remember, you are the one representing your organization. You are the one who at the end of the day signs that contract or is involved in the signing of that contract, and therefore you are accountable. Your organization relies on you to make sure that all of these procedures and all of this work is in place. And as an international executive doing business with other cultures, you have the duty to make sure that everything is there and you read the fine print thoroughly. No one wants litigation, no one wants things to go to court. And certainly if you have not read things thoroughly, or you thought you saw something, or you say you didn't know, no judge is going to really listen to you and accept that. So please remind yourself of this very important point. If you do need, at the negotiating stage, and we've talked about this prior to the program, if you do need assistance, then consult your lawyer. Negotiating can be tough, as sometimes there are difficult parts in the negotiation process and difficult points that need to be clarified. So something you can do is consult your legal advisor prior to the agreement or the negotiation terms being drawn up. This is important. It can actually prevent great mistakes being made. It can actually prevent a lot of work having to be redone and rewritten. So before you sign contracts, make sure that your legal advisor is very well aware of the contents. This practice will save you many, many, many headaches, and it could save you a lot of money in legal fees. Don't think that you'll wait till the end before you get that legal advice. Try to prevent things from happening by taking the time and perhaps spending a little bit of money on legal costs to ensure that every aspect of the contract is in place. So, working with international partners and looking at contracts on an international level is quite a time-consuming part of your role. And to help you along the way, there are some other do's and don'ts that I'd like to highlight for you in this particular part of your business role. If you're involved in the contract process, do start with some form of generic guide and adapt it to your particular situation. So you've got a basis to start with. This can help you, so you're not actually writing the whole contract. You're not expected to do so. All these steps can be followed if you just generally want to brush up on your knowledge of contracts. As I said before, you may not be the one writing the contract. There are organizations and companies who have very large legal departments who write contracts. But as you progress in your role, as you become more senior in your role, it is very important that you know the ins and outs of contracts and how they actually come about. So I take you through these do's part of how contracts should be prepared. Of course, as I said earlier, do make sure that it's clearly labelled contract, so there's no mistake of what the intention is of this document. Contract is known internationally. It is a term that every single company will know internationally. So this is how it should be labelled. Identify everybody very, very clearly and correctly. I have in the past, in my experience, seen names that are spelled incorrectly and addresses that are inaccurate. And this is a serious thing. You may not think it's serious, but actually in the eyes of an international partner, most definitely it is. And that contract is invalid if the wording is not correct, if the spelling is incorrect. So point 3 is a very important one to note. Your common language for this contract, if it is in English or whatever language you are using for the contract, ensure that the people who draft it know the language extremely well. So here you must make sure that spelling mistakes are not apparent in the contract. You may have to have it read through 3 or 4 times and spell checked 3 or 4 times just to ensure this. So that everything is clear right from the start, make sure that the date is at the beginning of the contract. And make sure that it is very clear, in full, so that there is no misunderstanding. That date of the contract will be referred to later, perhaps, in discussions and in other side agreements that you have. So that date becomes a very important identifier for the contract between the two parties. So ensure that that is in the first paragraph when you're beginning to open the different parts of the contract. Number 5 is a very interesting point. I have, in my own experience, gone through contracts where the headings make it difficult to find other parts or other provisions in the contract. So try to use common sense headings. That means headings and wordings that you and your other party understand very well. This is where I'm talking about using simple language. Simple language is the language that you and I speak, that you and your other party speak. There's no point in using legal language for headings or the wording when either party are going to have trouble reading through it and coming to terms with that contract. So do use common sense English and common sense headings that each party understands. That way, when you're referring to the contract and you're going through it, you may be saying, let's go to the part on services. Let's go to the part on delivery. Those terms are very easy to understand. So ensure that you maintain that easiness of understanding of the language. Point 6, number paragraphs for ease of reference. These are very simple functions to follow, but they do have to be followed, and it makes the whole business of the contract much more pleasant to work with. Plain language, as I said, is very, very important. And number 8, I think, needs to be emphasized as well. Do define all technical terms. Sometimes we assume that people understand the technical terms. If there is a possibility that that is not the case, then you do need to define them. Perhaps you can define them briefly in the same paragraph, or you can use an appendix that defines those terms. But it is necessary that technical terms have a definition somewhere in the contract. You know yourself, reading through contracts, you might say, what does that technical term mean? I'm not sure. I'm not sure what that means. If you don't have a reference, then that contract is a very confusing document, and it leads to misunderstandings, and therefore you need further discussion. So in order to make the contract a very pleasurable and easy document to work with, to save a lot of unnecessary effort and time, make sure steps are followed, as I'm going through now, to make it very simple and easy. The next set of do's that are very worthwhile to know is that punctuation marks. It may be that you're not familiar very well with some of the English language grammar, but consider using punctuation marks carefully in a document. Sometimes a misplaced comma, for example, may change the meaning of a sentence. I know in the English language this is definitely the case, and therefore you have to have someone very, very specialized, very knowledgeable of the language of the document who is involved in the drafting of that document. When you are reading the document, then it is important that if you see this, you pick up on it and you question it. If for some reason you feel that there is something wrong with the punctuation, then it may be true. And you have also a very good knowledge of the language of the contract, and therefore ask questions. Read it carefully, read it a second time, a third time, and if you have a question, clarify where particularly punctuation may change the meaning or may make the meaning a little bit ambiguous. And also, when you have wording such as and or, make sure that those are very, very clear as well. You will have people working with you on your contract, or maybe you are just going to be skimming and looking through the contract, being a part of the negotiation process and being a part of the party that brought this contract together. So therefore, you need to be careful with these small conjunctions we say in English, especially and, or. So it can also have a dramatic impact on the meaning of the contract. These are 2 points that may be a little bit difficult for you depending on your knowledge of English, but I do suspect that being involved in international negotiations and travelling to other countries and being involved with international partners, that you will have a certain grasp of the language, and therefore do take note of point 9 and point 10. So in the contract too, there is a need that every possible thing that may go wrong is also covered. All possible contingencies need to be covered in the contract. The contract needs to address these issues, and it is there, or these issues are there, these contingencies are there, so that nothing is left to chance. A contract is the agreement by which you are perhaps going to expend a lot of budget, and therefore to ensure that that budget is well spent, to ensure that all the resources you're going to put in place and all the services you're going to work on to deliver are not wasted and are not going to cause serious monetary problems if the contract is breached. You need to ensure that all contingencies are put in place in the contract to cover you and your organisation if things do go wrong. Point 12, of course, have your legal advisor look at contracts and work up a partnership with them, talk with them, try to get to understand through them as well all the parts of the contract. Every question you ask, and I really do mean this as it says in point 13, every single question that you ask is not a stupid question. You're dealing with a lot of money, you're dealing with a very important part of business when contracts are to be signed. So there is no such thing as a stupid question. It will be stupid if you let it go and you don't have it answered, and you might have to pay for it severely later on if things go wrong. So don't feel that the questions you ask, because you are what we say a lay person, you are not a legal expert, don't feel that the questions that you ask are stupid. Go ahead and ask them. That is your right, and that is your responsibility as well. Sometimes people feel a little bit embarrassed that they are going to be asking so many questions and it seems like it's such a simple thing. And people are a little bit concerned that the legal advisor might think that you don't know what you're doing. Well, let me tell you, you do need to ask questions. And I really do think your legal advisor will understand quite clearly that you want to be certain, that you want to be sure of things, and that is your responsibility to protect and safeguard the parties in that contract. Remember, you are working for an organisation, and contracts that you are dealing with may run into millions of dollars, millions of US dollars, for example. And that is not small money in our language. That is major concern. And even if it isn't millions of US dollars, for example, whatever the budget is, whatever the amount is concerned with that contract, you have the right and you have the responsibility to ensure everything is clear. So my advice to you is ask, ask, ask. Ask away. There is no problem with it, and I would encourage it. Step 14 is also interesting. Most contracts are drawn up in black, actually. The ink, the colour of the writing is in black. So sign in actually another colour. When you do sign in a colour other than black. This makes sense to me, and it makes sense in international business. And you need to do this so that you can make your signatures and the original distinguishable from photocopies. So that's an important thing to remember. Make sure that blue or a color other than the ink that the contract is presented in is the color you use to sign. Number 15, a very simple do. Every page in this contract needs to be initialed. Now, I think you've probably been in situations where there are 20 pages, 30 pages, even many more pages to a contract. So it may take time, but you do need to initial every single page of the contract as you have read it, as you know the contents. This ensures that the other party knows that you have been through every page, and also make sure the other party does the same, so that both of you at the end of the contract realize and can agree and acknowledge that both sides have looked at every single part of the contract. Every page has been considered and regarded, and every page has been signed off. If by law the document needs to be notarized, then include that. Make sure that that is included if it is required by law, if that is applicable. And, of course, retain a copy of the contract for your records. That goes without saying. And, indeed, you may retain 2 or 3 copies of the contract, depending on the rules of both parties, or what you both decide to agree on. So those are the simple do's, and they make a lot of sense, don't you think? They're fairly clear, they're fairly self-explanatory, and they're very valid. These are the do's that really are necessary to follow. Perhaps not only in international circumstances, but I would think perhaps in your home country it may pay for you to look at these do's when you're dealing with contracts within your home country as well. Now we come to the set of don'ts. And here, the first one is, don't use archaic or old-fashioned legalese, meaning very difficult words that are old-fashioned and are not generally understood and used in today's common language. They don't really add clarity at all. They are just terminology that legal advisors or lawyers like to use because it's their industry. It's the nature of their business. So please don't use things like the party of the first part or heretofore, particularly in English. In many other languages there are similar terms as well. So try to cut out the archaic, the very old phrases that are not usually adding any clarity to the document. Also, don't use very long sentences. Break them up. As I said before, use punctuation, use commas, and break things down into easy parts that are very clear to understand and easy to digest, easy to absorb. When you make the points very easy, then this makes for a very workable contract, a very usable contract. We would say a user-friendly contract. Overly long sentences just make the contract very difficult to read and follow. Number 3 is an interesting don't. And I think it's something that you do need to follow because I've seen it many times, a lot of repetition in a contract. Try not to repeat so much terms and phrasing unless it is absolutely necessary. It's preferable to go back and refer to a previous thing and refer to its number, which you have highlighted, rather than repeating the whole part in wording. This is why breaking things down and heading things and giving them appropriate numbering is very important, and it's an easy way to refer to matters in a long contract. This will really help you, and it'll save you going over pages and pages and pages just to go back to the point that you're looking for. So, in any items you need to repeat something, just refer to the previous part, and that is easy then to look at. Also, another party may write a contract in a different way. They may define terms, for example, in a different way to how you define terms. And so this is actually something that you need to make sure in the negotiation process that these things are pointed out and discussed. You need to come to a use of common language in the way you define terms, so there's no misunderstanding. A technical term in your particular country may not be defined in exactly the same way as it is in your other party's country. So be wary of this. And if in the contract the term needs to be clearly defined again, then make sure that it is included. Make sure that there is common agreement on the definition. As I said again, don't rush. Don't read hurriedly. Give yourself time. Have those 5 cups of coffee. Go and have that break and come back and reread and go through again that contract. You are the one who is accountable. You will be important in this contractual business. So you therefore need to read very carefully and understand the nuances of the language. If at the time of reading you need someone to assist you to understand the language, then do so. Please employ the services of somebody who is very, very capable to help you, be it a legal advisor or a translator involved in legal work that can help you with this particular part of the contract, the reading of it. And another point that is also a don't. Try not to accept, or actually don't accept, definitely, the other party's oral explanation and we come to point 6. Number 6 is talking about a very important thing that does arise. Sometimes if you are wanting an explanation when you are reading through the terms and the other party explains something orally of something that's confusing, you may really be confused at the end of that explanation. Don't accept the other party's oral explanation. It does need to be explained in writing because this is an important aspect of the contract. The other party may be very willing to try to explain it orally. The other party may try their best and you may think that you have a clear explanation. But if the particular term that needs the explanation is a bit confusing, it is important that you get that explanation, even though you may finally understand it orally. It is important, and I stress this, to get that written in writing. An oral explanation, unless you know the explanation, an oral explanation by the other party can be misleading. So please include that in writing. You may be finding that you want to save time, and to save time, you'll just accept what they say to you. It seems okay. My point here is protect yourself. And in international business, please make sure that you get that oral explanation in writing. It's not good enough just from what they say. Of course, their intentions may be very, very good, and they want to help. But please safeguard your organization with an explanation in writing. Point 7 is interesting. Make sure that before you begin, and you may be very eager to begin to act on the contract and get whatever you have agreed to do with your partner up and running. But be sure that you've got all your contracts in place first. Don't act according to the terms of the contract until both parties have actually executed the contract. The contracts are signed, everything has been stamped, all things have been delivered according to the contract, and now you can start acting according to the terms of that contract. Sometimes both parties are very, very excited and very enthusiastic at the thought of finally getting to do business together. But please don't rush in. Wait until those formal procedures are in place and that both parties have executed what they have said they will do in order for the terms to begin to work. Also, number 8, we're coming to the final don'ts of our lesson. Don't agree to a modification or a rewriting of some part of the contract without putting that in writing. The fact that you are going to modify part 3/1(2), for example. You need to actually put that in writing that you're going to modify that part. Don't just take it on word that that point will be modified. Have the fact that it needs modification put in writing, in a formal letter in writing to your party or the other party. This is to show that you are going to follow this step and this is the next course of action so that the contract can then reach final signature, so that the contract can be signed off in entirety with all points finally agreed to. And finally, we come to the last don't. Don't, as I said, assume that because you have a standard contract that looks okay, it looks pretty good, it seems to be in order, don't assume that that standard contract doesn't need a lawyer's review. Even though you may have used that standard contract as a contract for other parties in other situations, any change of circumstance needs to be looked at and needs to have a going over by your legal advisor. Even a slight change to a document might have a different meaning on other parts of that document. And as I said before, your knowledge may be sound, your knowledge may be good in terms of legal issues and contractual issues. That's part of your role. However, always play it safe and have the document, even a standard document, gone over by your legal advisors. It may cost a little bit extra, it may take a little bit of time, but these are great investments in making sure that you have everything in place and that your contract is going to be exactly what it should be, a perfect document that is there to allow both parties to work well together and hopefully without any breach taking place. Thank you for listening to this part of our international business communications lessons. Working with contracts is indeed a very detailed process, but as you become more and more used to and experienced with the documents and contracts themselves and what's a good thing to do, what's not a good thing to do, as outlined here in this lesson, then you will gain more confidence and you will be able to proceed working with your international partners in both the negotiation process and in the contract part of your business. You'll be able to proceed very, very well. Thank you for listening, and I'll see you in the next lesson. Hello there, and welcome to our next lesson on doing business in the international arena, and indeed doing business where contracts are involved. Being an executive, certainly this is an area where you need to hone your skills and to improve your knowledge. So I'm going to take you through the essential elements of a business contract, a little bit of revision on it, and then we're going to look at the international arena and contracts in that arena. A valid contract, as we have touched on before, is one that you know has to be enforceable by a court. So when you're putting contracts together or when you're looking at contracts, you have to watch out for the fact that they actually need to be enforceable in a court. We don't like to say these things. We don't actually really like to think that maybe there will be court action or legal action. But this is what a valid contract is, one that is enforceable by a court. So you want to be sure any contract you sign is enforceable. In a contract, both sides must have mutual consent or give mutual consent to what is offered and what is accepted. And the consent should not be coerced out of the other party. It has to be done, of course, by free will. If at all you may be a little bit hesitant or uncertain when you are signing that document, that means you are not going to sign a valid document because you are not doing it of your free will. If you are uncertain or you feel something, some anxiety perhaps, or you feel that you might be forced to sign the contract because there's no other time to do it, be careful. You are not signing of your own free will. In a contract, of course, something of value must be exchanged between the two parties, and that can be anything, but there must be something both parties must be giving. If both parties are not giving something, then it's more or less a gift. It's not really a contract. So in a contract, there are both sides giving something. So this is a valid contract. Just be wary of the fact that signing a contract, though, you must sign it of your own free will without any question or without any hesitation or resistance or being coerced. Also, and it goes without saying that both parties who sign an agreement must be, we say, sound mind, meaning that they cannot be a minor, they cannot be under the legal age. Of course, they cannot be under the influence of anything that may sway or upset their interpretation of things, and that means not under the influence of drugs or alcohol. And neither party can have mental problems or deficiencies that do not allow them to view things in the normal way. So sound mind is also another aspect to making a contract valid. And a contract to be valid must have a legal purpose. It cannot be for something that's illegal. Of course, we are not looking at anything illegal here. So all contracts that are valid are generally for purposes that are deemed to be legal purposes in our society. So, the question is, when would you take a contract to court? Now, these are the sorts of things that we all try to avoid. Nobody wants this action. Most contracts, generally, are completed to the satisfaction of both sides. We find that in the business world, most parties do adhere to the terms and conditions of contracts. But sometimes the reality is that there is a breach of the contract. A breach meaning that the terms and conditions are broken or not kept as they were supposed to, by either party, that could be. So, therefore, each party has failed to fulfill their part of the agreement. So, when would you take a contract to court? So, when would you take the other party to court? You would take them to court if you cannot make what we call an out-of-court settlement. But let's look a little bit further now at contracts in the international business world. As you well know, contracts are made every day. There can be very personal contracts, very legal contracts. In the broader sense, for example, a contract is two people exchanging wedding vows. They are making a contract between each other to live together forever, happily, etc., etc., etc. A person who has a child is making a contract in a way that they're going to look after that child, and that child is going to be their sole responsibility. Shoppers who are buying food in a market, they're making a contract in a way because they are paying a certain price to somebody else who wants their money, and so there you have a contract of sorts. So, in the broader sense, a contract really is a simple agreement that defines the relationship between one or more parties. And a commercial contract is an agreement for the purpose of transacting business. So commercial contract is a business contract, so to speak. As we said before, contracts can be by word, they can be oral, or they can be written. And written contracts, of course, record things. They also can be a simple memorandum or a certificate or a receipt in the simplest terms of a written contract. We also see that with written contracts, things are very clear. So in the simplest terms of a written contract, putting the price that was paid for something is very easy to see. There's no question about it. However, when we go into the more intricate world of doing business internationally, contracts take on a whole new meaning. And across the border, we say, across your own country's border, a contract takes on added significance. You are dealing in a distant part of the world. You're not dealing on your home territory anymore. And you are dealing with unfamiliar areas, perhaps. So doing business and looking at contracts on an international level means that you have to be sharper and you have to be more knowledgeable in how to proceed in this area. The creation of an international contract is far more complex. The process between you and your party of another culture becomes far more intricate. And in some ways, it means that you have to spend a lot more time to thoroughly go through these contracts because you're in what we call new territory. But that doesn't mean that you can't go through with it, you can't move forward. Of course you can. It just means that you have to polish up your skills, become more aware, and we're going to take you through some very important aspects of how commercial contracts are seen in the international marketplace. As I mentioned, cross-border transaction, and this is what we call international transaction with other countries, cross-border transaction. In this instance, parties don't usually have the opportunity to meet face-to-face every day to go through the aspects they need to cover. They also have different values, different practices, and the laws are different depending on their governments and legal systems. So these factors can lead to misunderstandings, and therefore it's very, very important that anything that needs to be defined in a contractual basis has to be written and written very, very well. So to avoid that miscommunication, writing contracts, written contracts are definitely the way to go when you're dealing with international partners. So there are several aspects that are very, very important when looking at partners who have different governments and different legal systems and different ideas about how a contract needs to be written and what it needs to involve. When we look at contracts, there's something we do need to consider, and that is which party drafts the contracts and also where the balance of power lies. For example, the balance of power between contracting parties usually goes in favour of the party that drafts the written contract. Sometimes we may prefer that one party, or you may prefer that you draft the contract. And indeed, in the negotiation process, the idea is for you to suggest that you draft the contract, because this gives you the upper hand. Even if both parties agree to everything, it still means that the party that drafts the contract usually includes provisions in that contract that are more swayed to their favour. So let's look at one particular part in terms of international transactions, and this is the balance of power. Now, sometimes the party who is most familiar with written contracts and whose country has more developed systems in terms of contract enforcement will be the ones who draft the written contract. And when this happens, it means that the balance of power swings to that party. The party who has the upper hand may insist on terms that they're familiar with and that are common to them, and the other party, who may not really understand those terms, may simply just follow. So be careful in this. When you are dealing on an international level, it is important that you try to understand all those aspects of the laws in the country where the contract is going to have more favour. So this happens. The balance of power goes normally to that party which is more familiar and has the upper hand, we could say, with the legal systems and has a more developed system to deal with contracts and contract enforcement. So this is something you need to watch out for. And this is where you do need your legal advisor to be very careful and to show you the way in terms of this particular area. Where is that contract going to be enforced if it needs to be enforced in a court of law? Sometimes inserted in a contract, for example, in the United States, a clause called the time is of essence clause. We mentioned this before. Time is of the essence may not be familiar to you, and the other party may draft the contract with this clause in it. It means that if you fail to perform the contract within the time that is allowed, it is a breach of that contract. So in cultures that place more emphasis on continuing business relationships, this clause has little meaning. You may not like this clause in your contract because the moment you miss out on one particular delivery, then you have breached the contract. So the party who may have drawn up this contract has included that clause and you are not familiar with it. So if you are unhappy to have that clause in there, then you have to say so. You have to try to work out a way that it can be defined if it needs to be included by the other party. You have to find out a way that it can be defined so both parties are happy about it. If this clause is used, it may have very little meaning to you because if, for example, you can't deliver for some reason on time, then you might renegotiate some of the terms in performing the contract. And therefore, this contract really will go ahead anyway because your relationship is far more important. So sometimes when clauses are written in there, you have to be very careful to look at those clauses carefully. If you are unfamiliar with them, if they actually don't suit the way that you do business in your culture, then you have to have those redefined and have that stated. So these are some points to watch out when you're dealing internationally, because the meaning of clauses can have different meanings on how another party views doing business. As I mentioned before, some parties are deal-focused and some parties are relationship-focused. And in the writing of the contract, then the way each party focuses has to be reflected in the actual wording of the contract. And both parties have to agree on that. Sometimes, in enforcing contracts that are one-sided internationally, courts and arbitrators may refuse because they feel that one party is unreasonably burdened by the actual contract. And therefore, this means that the balance of power has to be very carefully thought out in a contract when you're reading through it. If you feel that you are burdened unreasonably by the balance of power in that contract, then you need to look at it. you need to have it gone through by your legal advisors. So therefore, the responsibility of drafting a contract is a very, very heavy one, and the party who does draft it does need to be fair to the other party at all times. But in reality, this may not happen. So as a word of warning, be careful when it comes to the contract drafting stage. Be sure that both parties have, if possible, equal opportunity to go through it and have their legal advisors involved. We don't really want one party to be taking unfair advantage of the other. And sometimes this happens in international transactions. I know many cases where companies have said, or businesses have said to the other party, another culture, please, you go ahead, you draw up the contract, you've got more ability, your systems are more capable than ours, please go ahead, draw up the contract. If the other party is fair, very, very fair, then both parties may agree at the end of the day when that draft is there to be reviewed. But sometimes in reality, as I said, one party may take, and not intentionally, but because of how the draft is made, that party is seen to have an unfair advantage on the other. So fair business practices are very important at the international level, and this will encourage both parties to perform their obligations. So if fair business practices are adopted, and if both parties outlay very carefully and very closely their involvement in the drafting of contracts, then you may avoid enforcement and having to go to court if there's a breach. It comes down to actually also the trust that has developed between the two parties. Of course, if there have been long-term relationships and if dealings have been done before with the other party, then you tend to avoid this. And most contracts actually do not have to be enforced and taken to court. But it is good to know that you do need to see that sometimes unfair advantage can be given to one side, particularly the side who drafts the contracts. So this is something to look very carefully at when you're dealing internationally. There are rights and obligations too when we deal with cross-border parties. And it's very, very important to establish clearly the rights and obligations of each party when you are beginning the contract process. If terms are absent or ambiguous, if they're not clear, the parties will not be able to perform the contract. So therefore, the rights and obligations, these are two very, very important parts of a contract. The rights and obligations need to be very clearly laid out. If they're not, enforcement will be difficult. The court will be a little bit confused as to what the terms are because the terms were not originally clearly set out, and the intent of the parties will be unclear. So establish the rights and obligations and make sure those terms are absolutely crystal clear in the contract. You know, if you're in your home country and you're doing business and you have commercial contracts within your home country, usually if there are things that are missing or things that are not clearly defined, the parties follow the local laws and practices where they're very familiar. So it doesn't seem to be such a big deal, so to speak, because everything is available. You're here in your home country and you've got a lot of things right at your fingertips to get through this problem. But when you are dealing with parties from different countries, they are not here with you together. They are not physically right here with you. And so it makes things a little bit more difficult. And sometimes their intentions are not easily implied because they come from different legal systems. And they may use systems and business practices that you are not so familiar with. And this is why it's absolutely essential in your international contract to lay out the definite terms, absolutely definite terms. And if this may take a little bit more time than is usual, then that is what you have to do. As I mentioned just a moment ago, the rights and obligations across borders need to be laid out very, very clearly. You are not able just to get on a plane and go over and discuss something that's become a big problem because the rights and obligations were not clearly defined. These things have to be thought through first and discussed very, very clearly in the initial stages. In terms of doing business internationally, it's been recognized that these problems exist, where one country has different laws concerning business transactions to another country. And therefore, a move has been made to adopt uniform international laws so that all parties to any international transaction are subject to the same set of rules. That makes sense. Actually, it's good business practice. And so this means that people from different countries can have the same set of rules basically to follow doing projects together. For example, if parties to an international sales contract are from different countries and they have acceded to an international treaty or a pact, such as the United Nations Convention on the International Sale of Goods, or the CISG, then those two parties can rely on that international law to determine at least some of their rights and obligations. This is in place, and it is recognized now that these treaties and pacts, and there are several of them, are in place to protect the basic rights and obligations when both parties want to do international business. This has come about because this is the way of the world. We are a global business now, no longer just confined to our own boundaries, and therefore there are laws in place internationally that will address those rights and obligations of each party. But some terms, actually, you do need to rely on your own legal advisors for them. Sometimes, even though there may be law there to protect you and even international law to protect you, sometimes the application of those laws to the interpretation of a contract can lead to unexpected results. The interpretation is the key here. And so even though you may think that the law is there to protect you, it's the interpretation that sometimes can create the difficulties. So being precise is very, very important in your international contracts. It is best to define things very clearly and to be explicit so that both parties will understand what they are supposed to do and what they are entitled to receive. So each party can predict how things are going to go by knowing what is expected of them and what they will get back from you. Hopefully, your terms in your contract will be very explicit. That means so clear and unhindered by ambiguity that both parties will understand what they are supposed to do and what they are entitled to receive. So if there is a breach, there's a greater chance that the court will look at those explicit terms that you have both agreed on. And therefore they will be able to more closely predict the outcome. Both parties will know exactly what will happen because everything has been written explicitly. So having explicit rights and obligations written means you will be able to predict the outcome in the case of any breach. Dealing across cultures brings up all sorts of situations to think about. And people have different expectations. Signing a contract with a company in the US, for example, will be very different to signing a contract from a country, let's say from Africa, from one of the African states or African countries. and therefore everybody has different expectations. But well-drafted contracts can help to ensure that those people of diverse and different backgrounds can have a mutual understanding of their rights and obligations. Everybody comes to the table with individual expectations. That's a given fact. And that can affect the way they understand the terms. What is reasonable to one party, as I said, may not be reasonable to another unless you find mutual understanding. And this is an essential element in the creation of a contract. If it is lacking, then you will have problems. So mutual understanding right from the negotiation stage is exceedingly important, so that at the contract level there is no misunderstanding and no breach. The key to this is in the drafting of the agreement, and the key is also in the discussions you have at the negotiation level. First up, you should make sure that any provisions that are in the contract reflect the culture of the foreign party, and at the same time keep in mind your own requirements as well from your side. So you have to begin to understand and have a bit of empathy as to the culture of the other party. This is absolutely essential. You have to perhaps look a little bit more into that culture. Maybe you need to find out more information of the way they think and what they expect. Perhaps you need to research some previous contracts drawn up in those countries and try to find out what the best possible solution is. We are very different, and when it comes to parting with huge amounts of money, signing contracts where business is going to go ahead, then all of these aspects about what you think is right, what we think is right, all these aspects need to be drafted very, very carefully. It could be you need to simplify your side of what you expect to be able to match the other side so that they are clearly understood. And this also happens if the contract has to be translated into the other party's own language. So simplify the provisions as well. When dealing with other cultures, make sure that everything is as simple as possible and as clear as possible. And as I have mentioned before, don't use legalese, which is legal jargon or legal terminology, or phrases that are shorthand that you may understand, but the other culture, the other side, has no idea what you're talking about. You may understand it in your language, but they are non-native speakers perhaps, and they do not understand certain shorthand usage or slang. So therefore you need to bring your language to a common language that is clearly understood. So mutual understanding is a very important key to the drafting of documents between different cultures. Furthermore, you will need to actually find out the extent to which the other party is familiar with international business and international business law. If they've been trading for some time, then maybe they have gained an understanding to the way that transactions need to be drawn up between different cultures. And during your negotiations, actually, you should explore that. You should be talking to them very openly and honestly as to their capabilities and their knowledge of international business dealings. If they've done business before with you, then that's a good factor. But if they haven't, then you need to perhaps go through them and spend a bit more time on this as to how different cultures draw up their contracts. You also need to look at their business history as well, perhaps find out more about them so that you can draft your contract at the appropriate level, so that you can make sure that the level of their business history matches the level of your business history in the written part of your contract. This in the contract is a very important part because it outlines the character and the nature and the industry of that business or that organization. And so to make the contract a very good one, an internationally accepted one, then both parties have to have this part of their history written very clearly and in a complementary fashion. Do you know that when a contract reflects both parties very, very well and takes into account the differences in their culture and things are solved in terms of that, then it is more likely that the contract will be performed to the satisfaction of both parties. You will find that when you have spent this effort and this time to get that contract in place and well in place with all those things understood, then you may not have a breach at all. Both parties will move right ahead, will move to work to the terms of the contract. But mutual understanding, don't forget, doesn't mean that each party knows its rights and obligations before signing the contract, but it means that the parties are in complete agreement to your rights as well as their rights. They understand their rights, but they also understand your rights as well. So it's a total, complete acceptance of both parties' views. That's what mutual understanding means. And you find that disputes, if they do arise only when one party interprets something differently from the other. So a contract drafted to ensure mutual understanding helps to avoid or at least settle possible disagreements that may come up over performance. So interpretation is also the key. When you are drafting, make sure that when things are discussed, that everybody understands clearly the interpretation. And if there is some miscommunication or misunderstanding, get that interpretation written down so it's in black and white. So let's look at some tips to cultural success when you're dealing internationally and dealing with contracts with your international partners. I would just like to take you through some tips that will help you when you're dealing with people from other cultures. We have touched a little bit on this in the past lessons, but I'll just go through them to highlight them once again so they are in your mind. And first up, the first thing you would do is follow your host's lead when you are traveling indeed to another country. Your host is there. They are the expert of their own behaviours in their country, and so follow their lead in the way that they may greet or shake hands, etc. Second, practice politeness that is universal, smiling, warm and friendly approaches, and business courtesies that come naturally, exchanging cards, shaking hands, all those sorts of things. Be polite, basically, is something that will get you everywhere. It's your passport to the world, so to speak. Another thing, when dealing across cultures, listen attentively and listen with interest. When people see this, they switch on and they will start to listen to you with interest as well. Keep your hands, your body language fairly quiet. Don't be too outrageous or extreme in moving your hands around or walking quickly or rushing. So try to moderate your body language, and when you speak firmly with commitment and conviction, but warmly, so that it will invite the other party to speak to you. If you use harsh, boisterous, noisy speech, then quite often they will not respond. They will be shocked at the way you're behaving. So tone it down. Be moderate in the way that you use your voice and your language. Personally sign correspondence. If you're dealing with international parties, they love to see personal signatures, even in letters. When we write letters, we tend to sign off personally rather than have a secretary sign it off for us. Most international business is done this way these days, and it adds that personal touch. So perhaps that's something you might take on as well when you're corresponding with your international partners. Of course, you may get your secretary to draft your letter, but indeed I would think it a good idea to sign it off personally by yourself. dealing internationally, time, we say, most people do think that time is an important factor. And that therefore means quick responses to inquiries and orders, and also emails. People like to see that you are there responding back to their inquiry or their letter. In certain cultures, it's expected that at least action be taken on a letter or an approach. Indeed, in Western countries, we do like to see a response to an email or a letter within 24 hours. Even if you acknowledge first that you will be responding in the next day or so, then that is acceptable. And people warm to that. That is what is needed. Otherwise, the other party does tend to get a bit concerned, and they do tend to take things personally. So promptly reply to inquiries, or promptly reply, of course, to orders. That's normal business practice. It might also be good if you ask what language is spoken and arrange for a translator when you're going to be needing to meet your international partners. Perhaps you haven't met them for the first time and you've arranged this meeting, so you need to know what is the language you're going to be communicating together in, and then arrange for the appropriate translator. Don't leave it to the last minute. Don't wait until you get there and say, "Oh, I didn't realize." Your role, your responsibility in doing international business is to look at all these things first up. Another thing, just avoid generalities. Try to be specific. Try to not have preconceived ideas about how things are going to be done. Wait until you actually get to meet the people, to meet the other party. Then you will be able to define these more clearly. And something that is a very good point, I think, is lighten up a little bit. Try to laugh at yourself and be serious when you have to be serious. Try not to maintain a serious tone throughout the whole proceedings of being with someone from another culture. They're human too. And as I said in the past lessons, relax a little bit, add a bit of humour, and be friendly. At the same time, be professional when the time calls for it in your discussions. When dealing with parties in another country, personal commitment, or how much you are actually committed to making sure that you keep your end of the deal, is something that needs to be clearly looked at. You may feel very committed that you're going to continue your part of the bargain. However, sometimes you're unsure as to how the other party feels and whether they have the equal resolve or the equal commitment that you have. This is always a grey area, if I can say, where even though we've signed all our documents, even though we've had lots of discussions and dinners together and lots of photos taken, how committed are each of you to actually making sure the contract works? For example, does the timely delivery of your order have the same importance to the other party as it does to you? Is the other party committed to producing quality products that meet or even exceed your expectations? How committed are they to making sure that all the terms of the agreement do actually happen? How committed are they, and is their commitment matched to yours? This is a question we have in the back of our minds when we're dealing with parties that are across our borders. It can also happen when we're dealing with parties that are within our borders as well. That's a very true thing as well. So trust here, trust between the two parties as to how they're going to perform and how much effort they're committing to make sure it all works, is built on the personal commitment that each party demonstrates to the transaction. Whether you are international or whether you are dealing with domestic partners, this is a very significant thing. Your personal commitment, your personal effort, your personal dedication to making sure that things work. Just because it's written on paper doesn't mean that it's going to work perfectly. a part that comes with that is your personal commitment to make sure it does get through. You have to be there. You have to follow up with relationships. You have to ensure that every step of the way you're not sitting behind the scenes, that you are actively involved in whatever the business is that you've finally agreed to do together. So personal commitment is a very important factor in dealing across borders as well as in your home country. But sometimes it can be difficult to actually know whether that personal commitment is there. It can be more difficult to see it in faraway places with your partner in faraway countries. Someone who, for example, gives their promise to become obligated has made a commitment to another party, but the terms of that commitment really does depend on the word of one party against the other. In many cultures, bargains or deals, we can say, are completed only when parties meet personally. And sometimes that's when a handshake seals the promise. This is personal commitment. Your word is your word. Some people take this very, very seriously, and in some cultures, that is the only thing that is needed. I remember many years ago working for a Japanese corporation, a major one, and a handshake at that time was considered far more important than the 20 pieces of paper that were written in the document to follow that deal. The handshake is what tied the two organizations together. So in many cultures, handshakes seal the promise. In other cultures, however, they insist on the signing of a written, informal or formal contract, but they insist on signing something before a final commitment is made. So here we have personal commitment. How can we gauge whether the other party is going to actually commit? It may mean that that handshake is the very important thing that will do that, or it will mean that some form of written document needs to be made before any commitment will be made as well. So keep in mind, when you're dealing with people from different cultures, how do they make commitment? How will they sign off, we say, on this? This is something you need to talk to them about when you're negotiating. This is something when you're building your relationships together, you need to understand what is the commitment that they will make. How will you know that that is how they make commitment? Simple conversation can explore these areas and come to the final understanding of what their commitment will be. What form will their commitment will take? How will they show their commitment? You'll need to decide in advance whether to accept that evidence of commitment is going to match yours or is going to be comparable to what you accept. You need to meet them personally, to shake hands and gain that party's respect and trust. And it could be that the oral expression and a handshake is all you need to accept their commitment of that transaction or to the transaction. This is something that differs in different cultures. And once you've worked out what is acceptable to you, then you can go ahead. If you've shaken on a deal and that's fine with both parties, then that's how you operate. That shows that you both have committed towards the transaction. As I said, you need to be comfortable with whatever you agree on. You need to consider whether in writing is important or whether an indirect approach and shaking hands is going to be important to you. Sometimes you need to discuss this with your other party and try to ask the custom of the other party. If people are open to a handshake, for example, and that's what it takes, then depending on whether you want the business and whether you can afford the risk, then you will make your decision. It is true, though, in international business, though, shaking hands to seal a deal or to seal a bargain is the exception, not the rule. Indeed, in Asia, sometimes a handshake is enough. However, when you're looking at business on an international scale and you're looking in terms of major budgets and major financial layouts, then written contracts are mostly the way to go. Written evidence of personal commitment, even if you simply exchange a memorandum, is the most preferred approach in the international arena. One last tip when you're doing business internationally. The first rule of a successful international business transaction is also the last rule, and that is to decide how to resolve disputes before they happen. So this takes you right back to our earlier lessons in the negotiation process. Also in the planning process and drafting process of your contract. If you follow the rules and the tips made in these lessons and the discussions we've had in this program, then you will find that your contracts will be safe and secure, that you will not really end up having disputes in your contract. And the most important thing that you can do internationally is to develop that mutual understanding. This is the key. When you have that relationship and when there is trust, then you can move forward and most likely your contracts will be met very, very well. You will be more inclined to follow through with the terms and conditions you have to comply to, and therefore so will the other party. Mutual understanding will make your contract work, and the relationships you develop across cultures are the most important ones you can develop when you're doing international business. Thank you very much, and I will see you next time.